Our next speaker also has something to say about Aboriginal injustice with interactions with the legal system. Dr. Stephen Gray is a senior lecturer at Monash. His interests include criminal law, Indigenous people and the law, intellectual property and Indigenous art. He's also worked and studied extensively in the Northern Territory, and he's the author of a PhD thesis on stolen wages and an upcoming book called The Protectors. Please welcome Stephen Gray.
Thank you. I really do have some hard acts to follow here, although I must say to Manya, whose speech was incredibly impressive and moving, that I used to live at Darwin River, and I swear to you that we would lie awake at night and listen to the termites eating the walls. I would like, firstly, to acknowledge the traditional owners of the land on which we stand. I would also like to pay my respects to the Aboriginal people who worked for many years for little or no wages, whose labours have helped to form this country. As we're all too painfully aware, I'm sure traumatic events are taking place at this moment overseas. I would never seek to suggest that we as Australians should turn our backs on the rest of the world and focus only on our own backyard. At the same time, Australians have a long history of doing exactly that. Many Australians would be unaware of how extreme are the conditions currently existing on some Northern Territory Aboriginal communities and communities elsewhere. For example, evidence before a Northern Territory Parliamentary Committee in 2004 described a typical night on one community. For the most part, our people live in overcrowded circumstances. It's no exaggeration to imagine an extended family group of 8 or 9 people, ranging from babies and school kids through to aged pensioners, living in a 3-bedroom house. It's often worse than this. This is one night. It's a drinking household. It's noisy until late most nights. These are drunken arguments. Most adults are unemployed or underemployed on the local CDEP projects. A large proportion of the family income gets spent on grog, so there's often little food and bills are often unpaid. The kids are mostly hungry, which makes it impossible in school the next day. They're also tired as they were kept up last night. In any case, some of the kids are deaf, with hearing impairments. Poor water supplies and hygiene take their toll on up to 100% of school kids in some communities. The coppers were elsewhere last night. There'd been a bad smash on the road that night. 6 people, all drunk, had missed the crossing on the dirt road and were also in hospital. 2 were not expected to live. It would be a hard task for the Aboriginal community police officer, who's related to all involved, taking that sort of news to the family the next day. As anybody who has looked at the law in developing countries would know, one problem is the gap between the law as it exists on the statute books and what happens on the ground in reality. In such countries, in many countries around the world, developing countries, best practice laws may exist on the books reflecting international human rights, perhaps political UN, US pressure, but they're never enforced because there's little in the way of facilities, little administrative machinery, little money for enforcement. And you might think that this doesn't happen in Australia, or at least not in the same way, not to the same extent. In the Northern Territory, however, we have on the statute books a set of best practice laws relating to fitness to plead and mental impairment. That is, these are criminal law terms for laws designed essentially or partly to deal with people who have cognitive impairments, often brought on or exacerbated by alcohol or petrol sniffing. Many of those people are Aboriginal. The laws on the statute books provide a suite of options that are available on the statute books for dealing with such people. Custodial orders, non-custodial orders. There's a provision there which says that a custodial order committing a person to prison or to a lock-up, a closed environment, should only be a sanction of last resort. And indeed, it says on the statute books that courts are required to apply the principle that restrictions on a supervised person's freedom and autonomy are to be kept to a minimum, consistent with the safety of the community. You don't lock people up unless there's a really, really good reason. Things, however, are different in reality. There's no secure care facility. Nothing like what we have in Melbourne, the Thomas Embling Hospital, for example, anything independent of a correctional centre, a jail. According to one Territory case, Doolan, within the last year, construction of such a facility in the Territory is planned to commence in July 2010. It's just over a year ago now. Less than a year, actually. It's hoped, this case said, that one will be in operation about 9 months later. No such facility exists today, although one is supposed to be in the pipeline. Instead, mentally impaired defendants are kept in jails, designed as punishment. They're subject to a special theoretical status, a special status as a supervised person. They're kind of technically not prisoners, they're supervised people. And the correctional services officers, the trained prison officers who are there to deal with them, go to a course where they're kind of taught about how they're supposed to deal with these people, so that in theory they're not treated as convicted prisoners, despite the fact that they're there in jail with the prisoners. So, is it only in places like Bali that people with mental impairments are kept in jails designed for punishment, potentially indefinitely? It seems not. When we do put money and energy into issues involving Aboriginal people, and consistent with the Northern Territory intervention, which was just talked about, there have been 18 brand new police stations pursuant to this Operation Themis that are constructed in the Territory or in the process of construction. Big money for police stations, big money for police, more than the police actually wanted. But nothing so far for a facility like this. We still do it, I think, we as in the white people, the Europeans, the people who run the country, we do it in an assimilationist mentality, in a way that implies we know what's best for you. And you see coming out in media over and over again over the last few years this message to Aboriginal people which runs something like, you mob have made a mess out of your lives, you can't be trusted to work out solutions for yourselves. For years, decades, the Royal Commission, Ricky Dick that was mentioned earlier, innumerable government reports over that last 30 years or so, whenever Aboriginal people are asked about the solutions to problems, they have said that solutions have got to be worked out in consultation, from the ground up, by speaking to the people concerned. And usually, especially up north, they've said it's got to be done within the framework of customary law. Yet this is not what's happened these last few years. Instead, the general community has been bombarded with graphic images and descriptions of the worst things that happen on Aboriginal communities. Images of petrol sniffing, unremitting violence, sexual abuse of women and children. And added to that, adding insult to injury, is the view that these things are somehow traditional. That they existed, they've got nothing to do with colonisation, nothing to do with the history that's gone down that the other speakers have spoken about, father to son, parents to their children, nothing to do with that. That they predate the arrival of Europeans. I'd suggest to you that this is contrary to the evidence. If sexual abuse is a problem, it's a problem that's historically been visited primarily by white men upon Aboriginal women and children. I have to say with some shame as a white man myself. Regardless of what may have happened 200 years ago, we've seen a media climate created of public urgency, of hostility to judicial sentencing practices, which have supposedly placed too much weight on evidence about customary law, the bullshit customary law defence, inverted commas, intoxication and other factors from Aboriginal men. This perception that the courts are dealing too lightly with such people. As a result, there's been a return to an overtly law and order approach to these questions.